You are too.
I am in
Okay.
God's will.
First, an update, because yesterday we saw an application from your side citing the Electoral Commission for contempt. Why did you decide to make that move?
Well, it was a premise on the fact that the High Court in Tamale gave a judgment on the 24th of November 2025, wherein it made some orders directed at the Electoral Commission to conduct a rerun of the parliamentary elections. Now, we're monitoring the space. The Electoral Commission is basically has shown no intention or attempt to comply with the orders of the Honorable Court. And so we filed the application to draw the attention of the court to the fact that its orders were brazenly being disregarded and disobeyed by the Electoral Commission. You would notice that the third order of the court was served on the Electoral Commission on the 25th of November 2025. And so basically that is the reason why that to conduct an election, a number of activities ought to take place. You must announce a date for the elections. You must call the candidates to ballot for their positions, issue a notice of poll. Nothing at all has been done. And this has allowed the other party to go foreign shopping, filing all manner of applications, as though by filing applications, the orders of the court will necessarily be stayed. And so we intend to draw the attention of the court to the conduct of the Electoral Commission in disobeying its orders by that application.
And of course, you talk about the other applications that have been filed. Are you suggesting that those because I'm sure you're monitoring what happened in Parliament, the fact that the argument is being made that those applications should act as a stay, that no further action should have been taken until the stay of execution is heard and what has been filed at the Supreme Court is heard. Is that to suggest that you disagree with that point of view?
Most certainly we do. The orders of the court ought to be set aside or stayed by a court of competent jurisdiction. No activity besides that will stay that order. The fact that some people have constituted themselves into a court and openly professing an opinion as to what a certain order should not be complied with in a certain manner because some processes have been filed. This specifically is not the law. You must actually file the application, have the application heard in court. And when it is determined and an order made whether to vary or stay the execution of the order, then it becomes law. It becomes an order that has now been stayed, allowing whatever processes to go on. Now, those persons making that argument certainly know that in order to stay the execution of the court, you must file a process before the court. Go before the court and argue it. And so when that application is not determined, you cannot just stand on the street corners and say that because ABC applications have been filed, the orders of the court must or have necessarily been stayed. And that's not how it goes.
But I'm asking for a stay of execution, that no further action is taken. Whilst I have filed and served the people involved, you're saying that they should continue to execute the order when I'm clearly saying will that not in essence make my application moot?
No, not at all. So your stay of execution must be filed early in time. And in order to move the awesome hands of the Honorable Court to grant that application, you need to satisfy certain conditions and grounds. One, that you have filed an appeal, that that you filed before the court is to challenge the rightness of the decision of the court, that exceptional circumstances remain or prevail that should necessitate the stay of execution of the judgment. Among several other grounds. So you should file your application early in time. If you don't get a favorable date, you can bring an application to bridge the time so that application is heard earlier than the execution of the judge, i.e., the elections ordered to be run.
I see. There's also the point with the Electoral Commission where it is suggested that first it is the Parliament that has to notify the Electoral Commission of the existence of a vacancy before they take any further step. Is that also a viable argument to make, that it was not until recently that Parliament actually notified the Electoral Commission?
Well, so far as you are concerned, it is really neither here nor there. Let's put it this way. If a member of parliament, a sitting member of parliament, loses his life, and so such an event is clearly within the precinct of parliament, it's an information that is within the domain of parliament. Now, it behoves on parliament, I think per Article 99, to notify the Electoral Commission that a vacancy has occurred. Or let's say a member of parliament cross carpets in parliament and crosses the aisle and joins another party, other than the party on which he stood on its tickets to vie for the seat. In that instance, it is an event that has happened in the precinct of parliament, for which parliament ought to communicate to the Electoral Commission. The circumstance as we have it has it that the judgment was given by the court. The court directed its orders at the Electoral Commission. Necessary steps were taken to serve the Electoral Commission and Parliament, and you know that Parliament was initially a party to the suit, even though at some point they were misjoined. They are seized with the facts and the proceedings in the court. So once the order has been made and served on Parliament and the Electoral Commission, whether Parliament notifies the Electoral Commission or the Electoral Commission on its own motion per the order served on them, and they don't even need an order to be served on them because they are also a party to the suit. So I mean, well, people can entertain the matter of discussing whether it is appropriate for Parliament to write to the Electoral Commission, and whether if that event does not occur, the Electoral Commission cannot move the needle to do what they should do. That is a discussion that can be had. But in this particular instance, the orders of the court were directed at the Electoral Commission, and the orders of the court have been served on the Electoral Commission. The orders of the court are such that the Electoral Commission ought to know because they themselves are party to the case. So, I mean, it doesn't really matter whether Parliament writes or otherwise. The Parliament, I believe, was writing to the Electoral Commission by virtue of the mandate conferred by the Constitution. It's really not a big deal.
And have you taken note of the publications about the Electoral Commission having now set a date for the rerun?
Yes, that publication has indeed come to our notice as a legal team for Honorable Dana Salawapa.
Would they change your course in any way?
The publication is an expression of intent to organize the election on a future date, and they say the date is on the 30th of December 2025. It remains to be seen whether they will actually do so, but it's just an expression of intent. Like I said, we haven't seen any action on the part of the issue. We are basically exhibiting inertia. However, let us concede it's a step in the right direction. I wonder how they will juxtapose the publication they have now put out with the application that has been filed. The application seeks to hold them before the court to show cause why they should not be committed for contempt on the 23rd of December. I mean, a simple arithmetic will show that 23rd December is about 7 days shy of the 30th December date for the election. So, I mean, what they reserve a right to file an affidavit in opposition to come and show cause why the court should not hold MENSAH, the Electoral Commission, for contempt. I mean, commit them for contempt. Those are matters I won't speak to. But let's just see how it goes. But indeed, it is a step in the right direction. We would have hoped that they would have done it according to the orders of the court. And so we remain steadfast and resolute. We will stand by our application. If the Electoral Commission is able to comply with the orders of the court, the directives of the court, right, the applicants will withdraw the application and then life goes on at the time the application is to be heard.
Oh, so you're saying her actions will save her?
I mean, well, if you are cited for contempt, you have to purge yourself of the contempt. And if you remain aloof and appear in court and basically show that, because you see, the whole essence of contempt applications is to show that the respondent has disobeyed the orders of the court or has brought the authority and dignity of the court to disrepute. And so we have made a move. It behoves on the respondent to decide which options are available to her she will take. I mean, I can't speak to those matters.
And let me conclude with the stay of execution that was heard yesterday. Has a date been given for when the judge will make a decision?
Yes, the judge set November 18 December 2025 as a date to give its ruling. And both parties have been heard in court. The applicant has moved his motion for stay of execution. We have opposed him. We are patiently waiting for the 18th of December 2025 for the ruling of the court.
Yeah, before then, you would have been before the Supreme Court and dealt with that matter too.
Let's see how that one goes. I mean, there are some processes that ought to be taken to invoke the jurisdiction of the Supreme Court. I don't want to go into those matters now.
But have they filed an appeal at the Court of Appeal?
Has the Honorable Martin
Nyindam, has he taken that step?
Yes, he has. In fact, he has 2 notices of appeal filed on record, but as at yesterday, I think they have withdrawn the one filed earlier in time. So yes, I can confirm that there's a notice of appeal.
Thank you. Thank you for speaking to us.
Thank you too. Thank you for having me. And good morning to your cherished listeners.
A wonderful day to you too. Eugene Kwame Awiti is member of the legal team for the 2024 NDC KPANDAI parliamentary candidate, joining us on the line for a quick conversation on the steps they've taken. They've actually gone to court, asking the court to cite Madam Jean Mensah for contempt for failure to act on the orders of the court. Now, you've seen that statement issued by the Electoral Commission setting a date, 30th December. He says, if by that time they have taken enough steps to show that they are committed to executing the court order or complying with the court order, they might withdraw the application. Or else they can just go and, like he said, purge them. Jean Mensah can go and purge herself. We'll take a break. When we come back, we'll continue with this discussion on the matter of KPANDAI and speak to Director of Elections and IT for the National Democratic Congress, among other people.